All right, we're recording. Morning, everybody. Thank you for joining us. I'm Kurt Kessler. I'm the president of Real Estate to the Rescue of Homeless Animals in Chicago. And we are here today to talk about fair housing and animal accommodations. It's one of the largest or most common complaints that we see at the Chicago Association of Realtors as it pertains to fair housing. So today we have with us Dave Nasso, who is the Vice President and Membership and Professional Standards at CAR, Chicago Association of Realtors, and Rich Magnoni. Rich is an attorney here in Chicago and focuses a lot of his practice on real estate issues. I'm going to let these guys get started and take it from here.
Awesome. Thank you, Kurt. Thanks for having us. So first slide, just kind of talking about the background and the difference really between the ADA, which is the Americans with Disability Act, and the FHA, or Fair Housing Act. What's the difference between the two, and some background. So the ADA, I believe it became law in 1990, and it's a civil rights law that prohibits discrimination against individuals with disabilities in public life. So jobs, schools, transportation, public and certain private places that are open to the general public. And that law is there to make sure that people with disabilities have the same rights and opportunities as everyone else. And then getting into equal housing opportunity, you have the Fair Housing Act, or sometimes referred to as FHA, and it makes it unlawful for a housing provider to refuse to make a reasonable accommodation to a person with a disability that may need in order to have equal opportunity to enjoy and use a dwelling. And so one of the most common requests housing providers receive is for a reasonable accommodation for a pet, but as we'll talk about, these aren't necessarily pets. They're considered, either service animals or emotional support animals to an individual with a disability. And so that could be in the dwelling itself, certain public or common areas of a dwelling too. So that's kind of just a quick little background on those two issues. And as on the screen here, kind of the definition of two areas of the acts, and that's defining disability. So a physical or mental impairment that substantially limits one or more major life activities of the operation of a major bodily function. And then further than what is substantially limits, it's an impairment that makes it more difficult to perform daily life activities more than the average person. And there's not the need necessarily for medical or scientific evidence around that.
There's actually really a very broad list of items that can be considered a disability, being eligible for housing disability benefits, a confirmation from a healthcare professional, some determination of disability from a governmental authority, like an adjudication of disability in a court, or even the receipt of certain benefits if you're on SSDI or some Medicare or SSI for people under the age of 65. And the mere fact that someone has failed to qualify for some benefit is not going to mean that they are not disabled. So it's actually a very broad category when we're making a determination as to whether someone is disabled or not.
Rich, you want to go into what is a reasonable accommodation?
Yeah,
I'm sure that's also broad, right?
It is broad. A reasonable accommodation is when a landlord is being asked to make a change to one of their policies. For instance, a policy that says no pets are allowed, or a breed or a weight restriction with regard to a pet. And a disabled person has a right to request a reasonable accommodation, or basically a change to that policy. This is a place where one can ask the question, when is a pet not a pet? The animals that we're talking about for disabled persons are considered medical devices or medical services as opposed to pets. And so as a result, people with disabilities are able to ask for these changes. Landlords have to consider reasonable accommodation requests, and assuming that there is not an undue burden. So the acknowledgement is that there could be some form of burden. It merely need not be an undue burden. The landlord has to set aside their policy and accept an animal in a property. And what that generally means is that there are not going to be pet deposits. There are not going to be pet fees or pet charges. A landlord does not have an ability to charge a fee to consider a reasonable accommodation request. And so as a result, a disabled person is going to have an ability to ask for either a service animal or an emotional support animal without any cost or charge to them.
I think we're good for the next slide, and we can get into, so we're talking about service animals and emotional support animals. So what's the difference? What are the rules? So a service animal, by definition, is a dog that is trained to do work or perform tasks for the benefit of a person with a disability. And so the definition does define this as a dog. I believe several years ago, there was sort of a new carve out to also include miniature horses as it relates to ADA. But this service animal must be trained, although it doesn't necessarily need to be trained professionally, but it must be trained to perform a certain task. And it will obviously supersede any housing rules. And verification is not necessarily required if the disability is obvious for that service animal. We can go to the next slide. So emotional support animals, this is where things get more broad, and it's not specific to a dog with a slight carve out for miniature horses. This is an assistance animal that works and provides assistance or performs tasks for the benefit of a person with a disability, or provides emotional support that alleviates one or more identified symptoms or effects of a disability. And emotional support animals do fall under the Fair Housing Act. They can be common household pet species, so not limited to just a dog. And no formal training or no informal training is really required, especially if they're just there to provide emotional support. These, though, still supersede any housing pet rules. Verification can be considered, or a landlord can ask for verification in certain instances if it is not obvious. And we'll get into that in the next slide. Rich, if we want to talk about, so what is reliable documentation?
Yeah, so, well, first, in the event that the requester's disability is obvious, meaning that it is a person who is obviously blind, a person in a wheelchair, when there's an obvious disability, then documentation is not required and is not appropriate to ask for. However, when a disability is not obvious, a landlord must give a tenant a reasonable opportunity to provide some documentation. And so we have the Assistance Animal Integrity Act, which became law in 2020 in January. And that law provides that that documentation can either come from a physician or a medical professional, an agency, a health service, a mental health service provider, a non-medical service agency, or a reliable third party who's in a position to know about an individual's disability. So there's a broad range there in the Illinois statute. In addition, the HUD guidance goes on to point out it need not be a doctor. It can be a nurse. It can be a psychologist. There's a broad range of credible sources that can provide that documentation, and the documentation required from them is something to show a nexus between the disability and the service animal or support animal. They need to show that there's a therapeutic purpose. They need to show that there is some need for that animal that arises from the disability. However, a landlord cannot ask for an actual diagnosis. They can't ask, what is your disability? They merely need to know that there is a disability. In addition, if a tenant is asking for a reasonable accommodation for multiple animals, multiple assistance animals, then that documentation is going to have to show that there is a need for each of those animals. Both the state of Illinois statute and the HUD guidance have made clear that a certification from the internet without any kind of a assessment of the tenant or their disability related need is generally not going to satisfy the reliable documentation requirement. And upon a due individualized assessment of the documentation provided, if that is the only thing that is provided, a landlord would have an ability to decline the reasonable accommodation for lack of reliable supporting documents.
A lot of good stuff there. So kind of just in summary, if a request for a service or emotional support animal is made on the property, a landlord is allowed to verify the need for and function of this animal, and obviously can, should consider, does this person have a disability? Does the animal, is it clear that the animal alleviates or assists with the disability based on the documentation provided if the disability wasn't obvious, and is the request reasonable? And then we've kind of already touched on this next slide here, but just to put a point on it, when a pet policy doesn't allow for pets, there's obviously the Fair Housing Act addresses this, and a landlord's pet policy cannot supersede the Fair Housing Act. So regardless of a pet policy, the individualized assessment in certain circumstances should be met. Does the person have the disability? Does the animal alleviate or assist with that disability? And is the request reasonable? Again, we've sort of said that service animals, emotional support animals, assistant animals, these are not considered pets, and they should not then be subject to the same rules as pets, such as pet deposits, pet fees, pet restrictions that Rich touched on earlier.
There are going to be some exemptions, sometimes that these rules are not going to apply. Those are generally times in which the fair housing laws do not apply. A building, an owner-occupied property of 4 or fewer units, a single family home that is rented out without using a real estate agent, as long as that owner does not have more than 3 single family homes, those items are exempt from those fair housing laws. In addition, in making those individualized assessments, a landlord is not going to be required to accept an animal if it is too large for the specific property. So it's not that it's being declined because there's not a valid reason, but just because circumstances don't permit it. That does not go so far as to apply to rules with regard to perhaps an association that prohibits pets of a certain breed or whatnot, or even if there was a local municipal ordinance that prohibited a breed, those items would be preempted by the federal law here. But if a house is just plain too small to have a large animal in it, then that is not going to have to be accepted. In addition, if the reasonable accommodation places an undue burden, an undue financial hardship on the owner, they would have a right to decline that animal. And then with regard to those breed or size restrictions, while a landlord does not have an ability to restrict any particular size or breed of animal, a landlord can make an individualized assessment of the particular assistance animal. And if that animal is causing damage, if that animal is a danger to others, because it's had previous incidents where it bit people, things like that, then a landlord is going to be able to decline that animal. And then, of course, regardless of whether the reasonable accommodation is necessary, the fact that a reasonable accommodation is being made does not mean that the landlord has to apply different acceptance standards to a particular tenant. Sometimes that can be a tricky and difficult situation for a landlord in making that determination. But let's say that a tenant just plain doesn't have the credit score to qualify for a property. The fact that they've made a request for a reasonable accommodation is going to be irrelevant. They need to meet those criteria for acceptance. One other, I'll add a number 7 here at the end. A lot of landlords will want to tell a tenant, hey, my insurance rates are going to go up, or I'm not going to be able to keep any particular insurance. And that has been found as a valid reason to decline an animal, provided that the landlord make a duly diligent effort to look into other insurance, to find other insurance companies, and only then can a landlord make a denial. So there are going to be very few times that there isn't some insurance company that for a relatively reasonable rate is going to insure a property with an animal. That one comes up quite a bit.
All right, well, thank you guys. We have a couple of kind of predetermined questions that we thought we'd cover while we're at it here. So these are questions that often come up in conversations with the Real Estate to the Rescue Board and our community at large. So I'll let Dave and Rich talk about these.
Sure. So this first one, the association that my listing is in has a 30-pound weight limit for dogs. I have a potential buyer with a letter from a mental health professional stating that they need an 80-pound golden retriever for emotional support. Does the association have to approve? I will take this one since it's a bit more straightforward. Yes, you know, the association can't just say, too bad, we have a 30-pound weight limit, you know, to this individual here.
And next, I have a landlord that does not want any pets in their property. They do not live on the premises, and an applicant wants to apply with 2 cats. The applicant says she has cancer, and that the cats provide her relief and support during her treatments, does the landlord have to approve?
Well, in this case, the landlord likely has to approve, provided that the tenant can comply with all of the requirements in terms of providing documentation. The landlord in this situation is not exempt from the fair housing rules. The tenant who wants 2 cats is going to need documentation showing that those 2 cats are each necessary, and they'll have to provide some of that reliable documentation indicating that they have a disability, and indicating that each of those animals has some therapeutic needs, some alleviation or assistance with that disability. And if they can do that in that case, for something like a house cat, that is normally going to be considered very reasonable. And the landlord likely would have to approve that as long as that documentation was appropriate.
All right, my rental listing is a single family home with a fenced in backyard. I have a potential applicant that is in a wheelchair and wants to bring in his 150-pound miniature pony. Does the landlord have to approve?
I think this kind of is one of those, it depends, and it's most likely yes. I think, not jumping too far ahead, this is obviously a single family home, so it could be reasonably considered to be a larger property. Can the, if the person's in a wheelchair, is this pony, performing a certain task for this individual in the wheelchair? Or is this considered just an emotional support pony? If an emotional support pony, is this single family home being rented out with the use of a realtor, or is this just a property owner with less than 4 single family homes? So I think, most likely yes, subject to all of those questions getting answered and the proper documentation coming through if needed. Anything else to add to that one, Rich?
No, I think the very next question goes into the main distinction here, where we have now a rental listing in a 1-bedroom garden unit with a shared backyard, and that exact same disabled person in a wheelchair who has a support pony. I think that's where a landlord would have to make a determination as to whether that animal is too large for the specific accommodation. And I think as between the two, certainly there's a better argument that a 1-bedroom garden with a shared backyard is going to be inappropriate for that 150-pound miniature pony.
Couple more here. The association that my listing is at has a breed restriction against pit bulls. I have a potential buyer with a letter from an urgent care clinic stating that they need an 80-pound pit bull for emotional support. Does the association have to approve?
Yes. I mean, assuming that this tenant or buyer, passes any other qualifications. I think, though, Rich mentioned this under the exemption that, however, if there's a specific incident with this specific animal in the future, then this accommodation could be denied. But just the fact that it's a pit bull and the association has a restriction against pit bulls, that doesn't matter as it relates to the Fair Housing Act.
I have a landlord that does not want any pets in their rental property. They do not live on the premises, and a potential applicant wants to apply with an emotional support Chihuahua. The potential applicant has provided a printout of an ESA certificate for the Chihuahua. Does the landlord have to approve?
Well, in this case, once again, we've got a landlord not living on the property that is listed, so the fair housing law does apply, but the application of that law, when we start thinking about the documentation that is necessary to show a disability-related need, without something from a medical professional, without something from a mental health professional, without something from a third party who has cause to know, a certificate that is merely obtained online without any inquiry into the disability of the potential tenant is generally not going to meet the burden necessary to require that the landlord accept that reasonable accommodation.
And our last one here, my rental listing is a single family home with a fenced in backyard. I have a potential applicant that has an emotional support peacock. The tenant has a letter from a spiritual advisor that states the need for an ESA pet that does not have fur. Does the landlord have to approve?
Yeah, I think we have the same thing here. I mean, when we get to exotic animals, those exotic animals can be approved. Things like peacocks and monkeys and reptiles. But in those cases, the tenant is going to have a burden to get some reliable documentation that is going to demonstrate that disability-related therapeutic need. So we have two things going on here. One, is the peacock therapeutically necessary with regard to the disability? And then secondly, is a letter from a spiritual advisor going to be appropriate? Is that going to meet the standards under the Illinois animal law? Maybe they're a third person who has his cause to know, but I'm going to guess that probably is going to be closer to the side of the line in favor of a disapproval than an approval. If something like that actually exists, not only does there have to be knowledge of a disability, but then also that therapeutic need. And so a tenant that wanted an emotional support peacock probably wants to go about looking for some more solid documentation so that they can get an approval.
That's our last question, and I don't see any more questions in the chat. So Dave and Rich, thank you so much for your time today and your information and insights. These are all questions that our agents and our board and our community at large have all the time. So we really appreciate it. This video will live on our website so that people can reference back to it. Real quickly, folks, thank you again for joining us. Real Estate to the Rescue of Homeless Animals is a network of real estate professionals in Chicagoland that raises money and awareness for shelters, rescues, and most importantly, individual animals that need help. We love to just pay for the care of an animal that needs being rescued, paying for medical bills, transportation, that sort of thing. In the past and in the future, the way we raised that money was through events and fundraisers, which we're starting to plan for our first event in over a year. So keep an eye out for that information. We do collect supplies for animals in need, often sending that stuff to Chicago Animal Care and Control because they are always in need of assistance. Many of our board members are fosters and volunteers at local rescues and shelters. And the money that we donate to rescues, again, goes to medical care for neglected homeless pets. If you'd like to join us, please reach out to one of our board members. We have a new website that's going to be launching in a couple of weeks, and we'll send an email out to all of you when that's ready, as well as our first fundraiser in quite some time. We will be selling some t-shirts and swag, and that'll be out shortly as well. That's it for today. I thank you again, Dave and Rich and Christina McNamee, for putting this together, and we'll see you all again soon. Thanks.
Thank you.
Thank you.